Welcome back to the Law and Crime Trial Network. I'm Stacey Delicat. I want to bring you up to speed on the two big trials we are covering today. The Marine murder trial continues out of Lexington, Kentucky, where two men are on trial for shooting and killing young Marine Jonathan Price back in 2014 as he and his wife left a bar while they were celebrating her birthday. Earlier this morning, the prosecution rested their case. Defense for one of the defendants began opening arguments but did not call any witnesses, and after the lunch break, we expect to hear openings from the other defendants' attorneys. In the meantime, we are also following the big trial out of the Georgia, an area about 30 miles south of Atlanta, and that is in the murder trial of Timothy Coggins, a young black man who was brutally murdered in 1983. Two men now on trial, or two men now accused, I should say, charged with his murder. Frank Gebhart's trial has begun. The other defendant, William Moore, will be tried at a later date. The two men are accused of slicing and stabbing Timothy Coggins, tying him up with a chain to the back of a truck, dragging him, and then ditching his body in a field. It was a brutal murder, one that prosecutors and investigators say was racially motivated. They claim that these two men killed Coggins because he was speaking with a white woman. Now, Brian Claypool is a criminal defense attorney, and he is joining me via FaceTime out of California. Brian, thanks so much for being with us today.
Sure, thanks for having me.
And again, that case, the Timothy Coggins case, also on a lunch break. Just as soon as court resumes, we will bring you back the live feed from the Georgia area. But in the meantime, Brian, I want to talk about this case because it was a cold case for 34 years. Initially, when this murder happened, the case was kind of closed pretty quickly. Detectives didn't do much work looking into this. There are many allegations that simply no one cared because this was a young black man in the early 1980s. Racial tensions were high in the state of Georgia. But then last year, new evidence came to light. Some new witnesses came forward. Police were able to crack this case and arrest these two men, Frank Gebhart and William Moore. We know that a lot of evidence was lost over the course of 35 years. We know people's memories are impacted, right? Over time, stories change. How challenging is this from the prosecutor's stance to try this case, given the amount of time that has elapsed?
Sure. Yeah. Cold cases in general are very difficult because, like you said, you're lacking evidence. It's been destroyed. It's missing. Memories fade. But circumstantial evidence in cases can also have the same value as direct evidence. You just need a little bit more of the circumstantial evidence to convince a jury. But in this case, I think the real game changer is this admission by Gebhart, actually multiple admissions to more than one person, albeit they're jailhouse informants. But he's allegedly spouting off about having killed a young African-American man. So obviously that's a game changer. The second issue I think is really important in this case, and I actually used this ploy in the Dalia Dippolito trial. I still represent Dalia Dippolito in the murder for hire plot in West Palm Beach, Florida, and I did 2 jury trials for her. And in the first trial I did, I attacked the police department, the Boynton Beach Police Department, and I basically put that police department on trial. The prosecution is going to have to really dig in deep on this botched investigation. I mean, from what I've heard, it was just a terrible investigation. Evidence is lost, critical evidence, and I think the prosecution is going to have to bring in some of the law enforcement and dig in. You know, how could you let this happen? You're trained to preserve evidence. And Stacey, you know as well as I do, the first thing that law enforcement is trained to do is preserve evidence, especially in a murder investigation. So how is it that all this evidence is missing? And then create this inference in the jury's mind that maybe law enforcement was in bed with the defendants because of this racial animus.
And let's talk about some of the missing evidence, okay? The defense team in their opening arguments went through it. I mean, there are shell casings, plastic casts of tire impressions, soil samples that contain blood, the victim's blood-stained sweater, hair samples, an empty Jack Daniels bottle, a $1 bill that had red stains that were recovered from a store the day after the murder. These are just some of the pieces of evidence that have gone missing since 1983. Now, you mentioned what's going on with law enforcement here, I think it's interesting to add that 3 other people have been charged in connection with this crime, albeit not the murder. But the Spalding County Sheriff's Office has charged a police officer, Lamar Bunn, his mother, Sandra Bunn, and a Spalding County detention officer, Gregory Huffman, with obstruction of justice, and it has been reported that they may have had a hand in slowing down this investigation into Coggan's death. Now, can we say that these 3 defendants got their hands on the evidence and threw it out? No, but it does seem very fishy that so much evidence would be missing. I mean, I could see if there was 1 or 2 or 3 things, you know, but for so many pieces of evidence, and you try to think about this, I can't even imagine that all of this stuff was all in one box. Like we could say 1 box of evidence went missing, right? I mean, this seems like a lot to be missing.
I mean, Stacey, the evidence you have identified is colossal. This is monster evidence in a horrible, brutal murder. You described this murder. It's one of the worst murders I've ever seen. So you mean to tell me that law enforcement is not going to be on high alert to absolutely preserve this evidence? I think what prosecution has to do is strongly suggest that law enforcement and these other individuals who've been indicted were in on it from the beginning to hide this evidence, to protect this defendant, Gebhart. And remember in criminal trials when evidence is lost, we always argue, and I argued in the Dalia Dippolito case. In that case, we had a tape, a critical tape conversation of Dalia before she allegedly hired a hitman. She was in there with an undercover officer for a half hour. The tape is gone. And what I argued in closing in that case is, look, you can draw an adverse inference from that missing evidence. Somehow, in this case, prosecution has to say, we know why law enforcement destroyed this evidence. We know why these other individuals have co-conspired to obstruct justice, because the evidence they destroyed would have helped convict Gebhart. And you can't let this guy get away with it because law enforcement breached their fiduciary duty to hold him accountable. That's got to be a big part of their theme in this case.
And let's talk about DNA, because there's very little DNA evidence. There was simply, not the DNA testing capability. It wasn't even a thing back in the early 1980s. One thing that's interesting that I expect we'll hear more about as this trial continues, one of the things the defense attorney referenced in his opening statement was that, there's hardly any DNA evidence or there's no DNA evidence, I guess, directly linking Gebhart to the crime. That's what he says. He does say, however, we know that there is some evidence still around, including the victim's genes, his bloody genes. And the defense attorney said in his opening argument that they tested the blood on the victim's genes, but it didn't match Gebhart or Moore's. It's someone else's blood, but they don't know whose. What kind of seed does that plant in the jury's mind? I mean, sure, we could speculate, and who knows how old these genes were and whether he cut him, guess it wasn't his own blood. But is that a red flag that, hey, we do have the victim's genes, there appears to be some blood on it, but the DNA doesn't match these 2 defendants, and we don't know whose it is?
Well, that evidence is going to be really devastating for the prosecution, because here we had some evidence that's existing. So I'm sure the prosecution was holding out hope that, hey, we're going to get some DNA testing done. Hopefully we'll get a match, and then they find out they don't get a match. So as a defense lawyer, I mean, they're going to make a big argument about how that proves that Gebhart was not guilty of this crime. That's really going to hurt the prosecution. I think what's really tragic, Stacey, in this case is I believe one of the pieces of evidence that was lost, wasn't it a white man's piece of gray hair? I mean, can you imagine that? Yeah, that to
and
me,
that could be Gebhart or Moore's hair. Could be someone else's.
Are you kidding me? So look, if I'm the prosecutor on this case, I'm going to still be arguing that. Look, okay, well, we lost that. They lost it. But look, hey, it's a gray hair. This guy's got gray hair. It's a white dude. So look, let's face it. The prosecution is going to have to get really creative and really aggressive. And they're going to have to play this case a lot based on emotion. And don't underestimate emotion on a case of a brutal murder where they dragged this poor young man. I mean, this jury is going to be looking to hold somebody accountable after all these years. So I would not give up if I was prosecution.
And when you talk about the emotion, we know a big part of this case is the allegation that it was racially motivated, that Coggins was killed for talking to a white man. Now, something we heard in testimony today, and I do want to talk about these witnesses, these associates of the defendant talking about what he told them in terms of the killing. But before we even get to that, we're hearing over and over again that he constantly used the N-word, that he would only refer to Coggins as the N-word, not say African-American, young black boy, that he perhaps had some sort of affiliations with the KKK or the Aryan Nation. There were some allegations, the defense started to dispute this, he had a Nazi tattoo. So that alone, hearing about his racist dispositions, I mean, prosecutors say he still is a racist. What does that do, you know, to the jury and to the prosecution's case?
That's a great point. You were just reading my mind. Because apparently in these jailhouse disclosures, or where Gebhart allegedly told some of these informants that he had killed somebody, he didn't say, hey, I killed somebody. He said, I killed an N-I you-know-what. He used the N-word numerous times. So that definitely proves racial animus. Now, you combine that with the testimony you just showed a little bit ago of the man testifying that he saw three, remember he said, oh, I saw three white guys outside.
Standing outside the bar.
Yeah, well, that actually is helpful evidence. So in a cold case where you don't have a lot of physical DNA evidence, you can still put a puzzle together to get a guilty conviction with what you're talking about. But look, let's face it, what it's going to boil down to, a big part of this case is going to boil down to the credibility of these informants. So in other words, were they copped any kind of deal by prosecution for giving this testimony?
And
I mean, if not,
right, they have not, and they were asked about that on the stand. I mean, you know, Terry Reed, befriended the defendant in jail, was on the stand this morning. Upon cross-examination, they said, did you basically think this would be a get-out-of-jail-free card? He said, yeah, but hasn't happened. Similarly, other defendants, other witnesses rather, said the same thing, said that they were, another one, Jonathan Bennett, was asked, do you expect any benefit from testifying? He said, no, I would like one, but I wasn't promised anything. But still, I think, to your point about their credibility, certainly these are men who have been convicted of their own crimes, or at least are charged with their own crimes, and, you know, they may not be the most solid witnesses. Still, when you have at least four of them,
exactly.
Right? It's not one witness, it's not two. We have at least four people saying, you know, that, you know, one said William Moore said that Gebhart said, his co-defendant Gebhart said William Moore stabbed Coggins, dragged him down the road. You know, there are bits and pieces. Another inmate, Patrick Douglas, said that that Gebhart confessed about killing Coggins. That said, you know what, they don't have any DNA, so they can't get me. So I think when you have multiple people, right, saying similar things, it certainly does add credibility.
Absolutely. You just hit a monster point. I mean, remember the Bill Cosby trial, the power in numbers. I mean, the analogy is it's not just a he said, she said, or, you know, one person coming forward. You know, multiple women coming forward in that case. I mean, here if it's just one informant and they're like, hey, I thought I'd get a deal, you know, maybe you're more circumspect of that testimony. But two things favor the prosecution with these jailhouse informants' testimony. Number one, none of these folks are getting any deals, and that's going to be really important to the jury. And number two, what you just said, one person coming forward, maybe an aberration, maybe some ulterior motive, but three or four people coming forward, and how cavalier what he said, and they have attention to detail on what he said too. That's important, and I think the jury's going to be persuaded by that.
Well, Brian, I want to remind our viewers that this trial is on a lunch break right now, and just as soon as it resumes, we will go back live into the courtroom. In the meantime, I want to go back to some more testimony from yesterday, testimony which, Brian, you referenced a little while ago, and that's from Jesse Gates. He's a family friend of the Coggins family. He also dropped Timothy Coggins off at the bar that fateful night of 1983. We heard him testify a little bit earlier that he found it weird that when he dropped Timothy Coggins off of the bar, there were 3 white men standing outside of this bar. Certainly they're sort of laying the groundwork in his mind, maybe in hindsight, for what would happen. Let's go back now and listen to a little bit more of his testimony from yesterday.
Were you asked by the sheriff's office to help investigate the case?
No, I didn't. Basically on my own, because we had investigators.
When you were conducting your investigation, were you trying to develop leads out of the black community?
Yes.
Were you able to do so?
Yes. The ones that wanted to talk.
Again, I know there's been some asking of questions that seem to be an attempted qualification as an expert, but I haven't heard that we've gotten there yet.
Judge, I'm not trying to qualify him as an expert. This goes more towards the investigation and how it was conducted.
Okay. I think you can keep going for the time being.
Mr. Gates, did you pass on the information that you recovered or that you developed to investigators assigned to this case?
Yes.
Back in 1983, did you feel like the information that you were providing the investigators were acted on?
In my personal opinion, no.
Why do you feel that way, Mr. Gates?
I can't really say. But I just don't think that we done our jobs.
Were you ever told to stop investigating the case?
I was told to stop when they brought the GBI in. I was also told that I was a road deputy.
The case of Frank Gebhart, who was charged in the 35-year-old murder of Timothy Coggins, which prosecutors say was a racially charged, brutal murder. I have Bill Claypool with me. I'm sorry, Brian Claypool, excuse me, via FaceTime from California. And Brian is going to be here as we break down more of this case out of Georgia. The case now on a lunch break, and we're expecting trial to resume shortly. We will bring it to you live as soon as it does happen. But in the meantime, I want to take a quick break from this trial to talk about some of the other crime stories making headlines today.